Good morning and welcome once again to Employment Hour in 30. I'm John Scholes, your co-host Lior Samfiru from the Samfiru Tumarkin law firm. Lots to get through in the show today. The contact 1-855-821-5900 and help@employmenthour.com through emails. We'll get to those as well, and the severance pay calculator. This is a tool. If you've never used it, you're going to want to stick around to get informed and get some insight on how to use that. But we always start, Lior, with the reason why we're doing the show, really. Right?
Well, we're here, John, to talk about the legal rights that you may not have known that you have with respect to your workplace, your job. Maybe you lost your job. Maybe you're struggling with a problem. Your boss did something to you. You're upset, and you want to know what your rights are, what your options, what the law says. So we're going to talk this week, every week on the show about all those things. So if you're struggling and something's happened, these things can impact us significantly. We all spend so much time at work. So if you want to know what your rights are, we're here to talk about that. We're here to educate and inform, and we're happy to take questions. We're happy to be interactive, and I think you'll find it very interesting.
And online, employmenthourtv.ca as well, anytime. We'll also get to, a little later in the show, what you need to know about employment agreements. This is a huge topic that most people have no idea what they've signed or when they should sign or if they should sign one at all. We'll get to that. But first, we do a segment every week called The Week That Was, some cases, some stuff you've been working on through the firm, and it really enlightens and informs and educates people on what you do and how they should approach it, right?
That's right, John, and I always like to give people examples of some of the things that come across my desk, because if you're watching us right now, you may find yourself in that situation as well. You may identify some of those issues, some of those concerns, so there'll be some important lessons here. So this matter, John, I'm going to tell you about involved a gentleman who had been off work for a few weeks. He was diagnosed with fibromyalgia and was applying for long-term disability through his employer. He got rejected, and then guess what? He gets a letter from his employer saying, well, we understand that you were able to come back to work. Come back to work. We expect you on Monday. Well, he contacts the company and he says, I'm not able to come back to work. I'm still sick, and here's my doctor's note. The company says, we don't care. We understand that you're ready to come back to work, and if you don't come back to work, you resigned. So he calls me and he wants to know what gives here. I'm sick. My doctor's telling me I'm sick. I can't work. So do I actually have to go back to work? Well, the answer, John, is of course he does not. If he's unable to go to work, and if there's a doctor supporting his requirement to have an absence, the company can argue with that. All that really matters is what your doctor says. If your doctor says you can't work, then you can't work. The employer cannot question that. And if they try to penalize you, let you go, consider you to have resigned, that's wrong. Not only would that be a wrongful dismissal, John, that would also be a human rights violation potentially. And this gentleman also was rejected by his long-term disability insurance company. I see that very often as well. Insurance companies not approving disability when they should. We deal with that all the time. If you're struggling with that situation, you really have to give us a call so we can help.
How much leeway does an employer have when it comes to somebody on disability? You've said before that they can ask prognosis, not diagnosis, right? Is that correct?
That is 100% correct. An employer is allowed to know if you're sick, how long it may take you to come back to work, what limitations you have. They're not allowed to know what the medical condition is. Whether you have a broken back or you're suffering from depression, it's really not the employer's business. They don't have a right to know that. So oftentimes employers try to exceed their boundaries in the information sought, and that's wrong. That's a private matter. So all you have to tell your employers, can you work or can you not work? And if you know when you'll be able to come back to work, you should provide that information as well.
The number 1-855-821-5900. That'll put you in touch with either Lior, another lawyer on his team. You can call that number anytime. We'll get to a phone call here this morning. We got Jim on the line. We'll see what he has to say. Go ahead, Jim.
I work for a trucking company. Been with the company for 4 years. I have a perfect record, never been written up, never been late for work, never called in sick, nothing. I got a fine 2 weeks ago, and the company wrote me up and suspended me for a week, unpaid, for a first offense. Can you write you up and suspend you for a first offense?
Well, John, at the end of the day, let me start off with this unpaid suspension. A lot of people don't understand that. An unpaid suspension is actually illegal. An employer generally does not have a right to put an employee on an unpaid suspension. A paid suspension is different. An unpaid suspension usually results in what we call a constructive dismissal. An employer can't decide not to pay you even if you've done something wrong. So with respect to this employee, if in fact he did something wrong. The employer has to make its own determination. And yeah, he may be disciplined, but he cannot be suspended without pay. So he may have a choice here, which is to accept this suspension without pay, go back to work, or he can treat that as a constructive dismissal. The problem with him accepting this unpaid suspension is once he's accepted it, he's given them the right to do it again in the future. So in the future, if he does something wrong, they could potentially again suspend them without pay. So it's illegal to suspend the first time without pay, and an employer should make its own determination. If he got a ticket, that may not be enough. They actually have to determine that the ticket was valid, that there's a reason to discipline him, and only then can they impose discipline, but not a suspension without pay.
So until they've determined if the ticket was valid, if it was him, if they suspend him without pay, they've kind of said he's guilty before he's actually been found guilty.
Yeah, certainly if they're investigating.
Right.
So we want to determine if you did something wrong. In the meantime, we're going to suspend you without pay. So you're punishing someone in order to determine if they should be punished. That's literally putting the cart before the horse.
Right.
So you cannot do that. If you're going to suspend someone pending an investigation, then it has to be a suspension with pay. Anything else is improper.
You have questions on the outside of show hours or any other time. Terminationquestions.com is the website you want to use. We'll get to one here. It says, I was poached from another organization. My boss has turned into a real demon. She's fired 9 people in 9 months. I'm on a 6-month probation, 6 months, and they have the right to let me go at any time. What recourse do I have if she fires me?
Yeah.
That is awful.
It is awful. And imagine being poached from another job. So you leave a job, presumably with all the best intentions, to join another company, and bad things happen. So first of all, the question was, what rights does she have if she's being let go? So clearly she's going to be owed severance. Not even a question about that. But because she was poached away from another job, she may in fact be owed enhanced severance. Her severance may recognize her service with the previous company. So that's important. What we want to see here, John, is her employment agreement. We'll talk later in the show about employment agreements. But what I hope she did not do is give up some of her entitlements in an employment agreement. And certainly if her boss is mistreating her, and even if they don't let her go, she may be able to issue or to deal with this as a constructive dismissal, to actually make them terminate her employment, because no one should actually have to suffer in a poisoned work environment. That's one of the most basic rights that we have as employees, that we work in a proper, supportive work environment. And if it becomes poisoned, we may be able to leave and require the company to pay us severance.
A couple of things you said, though, about being poached. I mean, that's I guess, officially or legally called an inducement. For another company. 6 months probation. First of all,
Yeah.
you wouldn't think there'd be a probation for someone who was brought from another company. They want you. You've already been on probation. They like you. And is 6 months legal? Can they do 6 months probation?
Well, that's why the employment agreement is so important, John. Certainly, if she had talked to me before she started with this company and they were poaching her, I said, well, you don't want to agree to a probationary period. Why leave a secure job to be on probation? It makes no sense. Now, certainly, if the purpose of the probationary period is to allow the company to let her go without any compensation, that would be illegal. It's not worth the paper it's written on. That period of time during which you can be let go without severance can only be for 3 months, and only if the employment agreement specifically says so.
So if you'd hired me, I'd been in my previous job for 17 years. I've been with you for a month. They have to recognize my previous service if I'm let go?
First of all, I wouldn't hire you, John. I know you too well. Yeah, that's true. But that aside, yeah, if I had hired you from another job, if I came to you and I convinced you to leave and you weren't shopping your resume around, and then I hired you and let you go shortly thereafter, I may actually have to recognize your 17 years with the previous company in paying severance. You may have only worked for me for a year, but you may be considered an 18-year employee for the purpose of severance calculations because I came to you, because I poached you, I induced you to leave another job.
Help at employmenthour.com. You have employmenthourtv.ca and 1-855-821-5900 anytime to get hold of Lior, another member of his staff. I mentioned off the top, severancepaycalculator.com. This is an invaluable tool for finding out the correct amount, and I stress correct amount, of how much severance you get. How does it work?
John, it's a tool that I created some 4.5 years ago now. It's a tool that allows anyone to find out exactly how much severance they're owed if they lost their job. So it's a free tool. You go to severancepaycalculator.com, and it gives you the real information, not your minimum entitlements that the Ministry of Labor outlines, your full entitlements, what we call common law entitlements. So severancepaycalculator.com, you answer 3 simple questions. It's free, it's easy to use, it's anonymous, there's no strings attached here. So I always say, if you lost your job, you're holding that severance letter in hand, you want to know, what does this mean? Is this legal? Well, guess what? You don't have to wonder anymore. You don't have to figure out where to go. SeverancePayCalculator.com. In seconds, you're going to find out.
Someone probably trying it out there now, using it for the first time, they're going to say, okay, according to my severance offer says 6 weeks. Your calculator at the end of the metric says 6 months. What's going on?
Well, let's use a real-life example. Right. So, let's plug some numbers into the severance calculator. So let's talk about an employee with 6 years of service, 51, a professional, perhaps an accountant, use a salary of $65,000. It's very common and very likely when someone in that situation would be let go, they'd be offered 6 weeks' pay. Well, you plug that into the severance calculator, and what do you get? You get about 8 to 9 months' pay. 8 to 9 months pay. So in that example, the difference there is over $40,000. And the reason I picked this example, this is a common example, John, that I see in my office all the time. People are coming to see me with tens of thousands of dollars of additional severance owed to them. So again, that's why it's so valuable. SeverancePayCalculator.com.
And they can click on the bottom and contact you right from there as well,
If they want to, there's a green button. They can contact me directly from the calculator so I can actually help them get what they're owed. But otherwise, it's strictly there for your benefit.
1-855-821-5900, the number to get a hold of Lior anytime. You can go to help@employmenthour.com through email as well. Some of your emails and more of your phone calls after we take a short break. The Employment Hour in 30 right here on Global.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And back with more of the Employment Hour in 30. If you haven't caught the weekly radio shows with Lior and myself across Ontario, we do an hour and we condense it to 30 minutes here for the purpose of this show on your Saturday morning. Phone calls 1-855-821-5900. You want to ask questions, ask Lior, another member of his firm. They will be answered. That is the number you want to call anytime. We'll get to a phone call from Peter here.
Lior, I'm 60 years old. I've been working as a senior sales rep. I make a pretty good income. Company has hired a couple of new sales reps. Basically half of what I make. They would love for me to just retire and walk off into the sunset, and I'd really love to go, but I don't want to go. I want them to pay me to go. What do I do?
Smart. Don't go.
No, don't go. Don't go at all. Unless, John, they've done anything or are doing anything to make his life more difficult, to make his life miserable and uncomfortable. If that's the case, so if Peter's employer is now doing something to try to push him out, well, as I said before, this could be considered a constructive dismissal, which means he can potentially treat his employment as being terminated. But assuming that's not the case and he wants to leave, if the company wants him to go and he doesn't mind going, what's to stop him from going to the company and saying, tell you what, I'll leave, let's work something out. So it may not be 100 cents on the dollar in terms of severance, but if the company wants him gone, they may be willing to pay. Now, the rule, of course, John, is that you only get severance if the company unilaterally decides to let you go. Right. If you resign voluntarily, then you don't get severance. But nothing's stopping Peter or anyone in that situation for contacting the company and saying, let's talk about it. You probably want me gone, I'll go. But let's talk about the monetary terms. In many situations, that could be effective. There's nothing wrong with doing that. And if Peter tries, it wouldn't surprise me at all that he can work something out with his employer.
EmploymentHourTV.ca or help@employmenthour.com as well through email. I wanted to talk about this today as well. This is something you may not even know you'd signed it. Maybe you didn't sign one when you first started work, which could be a good thing. We'll get to that.
Right.
And that is what you need to know about employment agreements. So we'll get through some of these talking points and we'll get through them. First one, why are they so important, employment agreements?
Well, John, I started off by the show today by saying that we spend so much time at work, and most of us spend more time at work than we do anything else. We probably spend more time at work than we spend time with our family or on vacation or doing our hobbies. So the employment agreement is the document that governs what we can and cannot do at work, where we spend most of our time. That's why an employment agreement is so important. A lot of people don't appreciate the importance, and we're going to give some examples as to why it's so important, but it's an extremely important document. And not only does it govern your employment, which is a reason enough to care, an employment agreement could be with you for a very long time, even after employment comes to an end. So it's very, very important to pay attention and to be very, very picky about what you sign.
So what's better, old school handshake or a 55-page document? I know what you're probably thinking, but what's actually better?
I have received, John, so many calls from people who have received a job offer. They received a 1 or 2 paragraph letter, and they call me very concerned, very upset, saying, I'm taking this new job on, and they're giving me this 1 paragraph document. I need to add things to it. I want a more comprehensive, more extensive document. Well, don't worry about that. That's exactly what I tell these individuals. Don't worry about the 1 paragraph document. Worry about the 30-page document with a lot of legalese, because I can promise you that in that document, that big document, there are going to be a lot of terms that are going to be unfavorable to you. For an employee, it's far better to start even on a handshake or on a very short document. All that means is that you have the full protection of the law. What a written agreement does is usually take away some of those protections that you have and either eliminates them or turns it around and gives it to the employer. So in that regard, if you're an employee, if I'm talking to you as an employee, you don't want to have an employment agreement. On the other hand, if I put on my employer hat on, I say you shouldn't hire someone without an employment agreement, depending on your perspective. But either way, it's a very important document.
Isn't it really less is more in that case? Right?
Less is more for the employee, and more is more for the employer.
So what should an employee, if they're signing an agreement, what should they be watching out for? What are some of the signs?
Well, John, most people that I know, probably people that you know, if you received a job offer, what are you going to look at?
Salary. How much holiday time I get,
yeah.
I get bonuses. That's probably it.
That's probably it. Yeah. My salary's fine, bonus looks good, I got my 4 weeks vacation, yep. I'm a happy guy. And that's fine, and I'm certainly not suggesting that you shouldn't look at that. But what I'm here to say is there's other terms, at least as important as those, that you need to watch out for. Just one example may be a term in the agreement that limits your future severance. Right. You may sign an agreement not realizing 5 years later when you were let go that document from 5 years ago limits your severance. And now instead of getting 12 months pay, you're going to get 6 weeks pay. So that costs you tens of thousands of dollars. How about a non-competition obligation that says that you can't work in the industry if you lose your job? There could be terms also, John, that allow the company to change the terms of employment. So you may sign an agreement to be the marketing manager making $80,000 a year, but all of a sudden, the agreement actually says that we can change your job, we can change your pay. So the job that you've had is not actually the job that you're going to have. So that's why it's so important to look at other things other than just pay and to understand. And if you don't understand what you're signing, that's a problem. You should never, ever, ever sign something without understanding what it means. You can give me a call. I can interpret it to you in simple English and tell you whether you should be concerned.
1-855-821-5900 is the number Lior just mentioned. What you should know about employment agreements moving forward. Do you have wiggle room? Can you negotiate all before you start, or at least sign?
Well, probably the first thing I am told by individuals when I say this is not good, that's not good, is, well, can I negotiate? The employer has the job. I want the job, so what power do I have? Well, the reality is, John, that you do have something the employer wants, and that is yourself. If your employer has gone through an interview process and they've decided at the end of that long process that you're the right candidate, you're the better than the other candidates that they were looking at, well, then you have something, that you have some leverage. And you can use that leverage. Ask yourself this, John, will your employer want to lose their perfect candidate if that candidate is concerned about job security? In most situations, the answer is no, they're not going to want to do that. So you can negotiate, you should negotiate, and in fact, you should tell your employer what your concerns are. I wouldn't go back with 25 things, a laundry list, but narrow it down to the 2 or 3 things you care about the most and approach your employer about those.
Okay, so I've signed the agreement, now I'm ready to work. I didn't get any advice. So what?
Yeah, and a lot of people think that just because they didn't get advice, now all of a sudden they can get out of it. If you sign it, you have to live with it. That's always my mantra. So even if you didn't have an opportunity to consult someone like myself about your employment agreement, you're going to be bound by its terms. That's why it's so important to understand what you're signing and not try to get out of it later. There are ways to get around and out of employment agreements, but I would rather not have a fire than try to put out the fire. So that's why I say be proactive. If you have a job offer, congratulations. That's wonderful. But give me a call. Let's understand what you're signing.
We'll take a short pause, a quick break. 1-855-821-5900. When we come back, we'll talk about maternity leave rights and performance reviews as well. The Employment Hour in 30 right here.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Employment Hour in 30 continues here, employmenthourtv.ca and help at employmenthour.com. The phone number, 1-855-821-5900. We'll put you in touch with Lior, another member of his team. We'll get to a phone call now. Got Arthur on the line.
I'm 61 years old. I'm a senior manager in a company. Just had a major change of CAO. Had a review recently, very poor review done. This follows 12 reviews I've had that were excellent. And I'm attributing it to the fact that they're looking to scale down the senior management team and using this as one of their means to do it. Would there be any merit in retaining a lawyer to issue a letter to the employer, letting them know that I'm aware of what's going on?
Well, first of all, if he's received 12 good performance reviews, I don't think overnight he turned into a bad employee. I don't buy it. So something here is fishy, something here is off. You don't just work for all these years, you're a great, stellar employee, and all of a sudden overnight now you're causing problems, now you're going to be maybe put on a performance improvement plan. It means that there's something else going on. And it's possible, as I think Arthur is suspecting, is that what they're trying to do is to build up a case against him. They build a case to potentially let him go, potentially even for cause. What I mean by that, John, is all of a sudden, if you're in a situation where your employer is now treating you in a way that you can't do anything right, everything you do is wrong, you get written up, you get criticized, you get warned, maybe even suspended, then your employer is doing something. And that is, it's trying to build up a case to let you go potentially for cause without any severance. Remember, it's very difficult to terminate someone for cause. What I would want Arthur to do in this situation, this is very important, is if his employer is building a case, he needs to respond to it. He can't just be quiet and accept it. So what I want him to do is I want him to respond. If they give him a bad performance review, if he disagrees with it, say so. Send an email, send some sort of a memo, and in that email, say why that's wrong, why the performance evaluation wasn't fair, what they didn't consider, what other information they need to have. In other words, explain your side of the story. Because the problem is, if you're just silent and, oh, I got a bad performance review, I'll move on. If that's wrong, well, you're deemed to have accepted it, and then it's going to be very difficult later on to oppose it and to object to it and say that performance review from a year ago was wrong. So I think his spidey sense, if you will, is probably right. They're probably trying to push it. So let's be careful here. Let's respond to them. Let's put our position in writing. And if they do try to let Arthur go, I want him to call me. It is time to retain a lawyer, mainly because I want to make sure that it's handled properly. I want to see his response back to the company. I don't want to give the company more of a chance to let him go for cause. If they let him go, he really does need to call me.
Arthur, that number you probably know, 1-855-821-5900 to get a hold of Lior anytime. Make that call. Email as well, help@employmenthour.com. We'll get to one from Sarah. Says, I'm 5 months into my maternity leave. I got a call on Friday that the company doesn't have a job for me and that they will be paying me severance. Are they allowed to do this?
Well, no, John, they're not allowed to do this. So let's break this down a bit so that people understand why I've come to this conclusion. So if you're on a maternity leave, you have a right to your job. Let's start with that. You have a right to go back to the same job, the same pay, the same location. The company can't decide that they're not going to take you back. Maybe they like your replacement better. They can't do that. Now, in some legitimate situations, maybe the department is shutting down. They can let you go if it's completely and utterly unrelated to your maternity leave. Now, in this situation, what I don't know is it in fact related to her maternity leave? But let's give them the benefit of the doubt. Let's say that they're not letting her go because of the maternity leave. Well, she said that she's only 5 months into her maternity leave.
Right.
Presumably, she was going to be off for another 5, 6, 7 months. Well, how can the company decide today that they don't have a job for her 7 months from now? They may not have, exactly. They may not have a job today, but by next week, next month, 6, 7 months from now, they may be desperate for someone with her position and her skills. So because of that, what they've done is they jumped the gun, John. They absolutely completely jumped the gun, and they've provided her with notice when she has a right for her job. So to me, this is a breach of the Employment Standards Act, potentially a violation of the Human Rights Code, and I bet you anything she's also owed more severance than what they're offering her. So this is absolutely the right time to give me a call. And for all those out there, if you're on a maternity leave and you are let go, that's a problem almost in every situation. The company is not allowed to do that in almost 99% of the cases. If that happens, you have to give me a call.
It's like we've been saying for 4.5 years on the radio show, don't mess with mama.
You don't.
Don't mess with mama.
But isn't that obvious? Shouldn't that be very obvious?
Yeah.
I don't think we invented this concept. But for some reason, I still get calls, I still get emails, I still get people contacting me all the time where their employer does not properly deal with the maternity leave, and that's wrong, that's illegal, and the law also comes down quite hard on employers in that situation.
1-855-821-5900 is that number. Help@employmenthour.com. We'll get to one from Danielle referring back to the severance pay calculator, which we talked about earlier. It says, can Lior explain why there's such a big difference between what the severance pay calculator says and what the Ministry of Labor says?
Yeah. John, this is probably one of my favorite questions to answer, and I get it often in my office. I get it often on the radio show that you and I do together, and it's an extremely important question. So let me break this down. When you contact the Ministry of Labor, and by the way, the Ministry of Labor also has some sort of a severance calculator on their website, but what the Ministry of Labor does and what the Ministry's calculator does is it outlines what your minimum entitlements are. Now, those minimum entitlements, John, are just a small portion, a small fraction. They're minimums.
Right.
But the thing is about the minimum is the law also has evolved beyond that. And the courts have decided over the past 150 years that you have additional entitlements under what we call our common law. And when you contact the Ministry of Labor, you'll find out what your minimum entitlements are. You will not and you cannot find out what your full entitlements are. That's when the severance calculator comes in, severancepaycalculator.com. It provides not what your minimum entitlements are, what your full entitlements are. And those could be 5, 10, 20 times even more than your minimum entitlements. That's why it's so important to use the severance calculator. I remember one time, John, I had a discussion with a gentleman who called me after he used the calculator. And he asked me this question: why does the Ministry of Labor, Lior, tell me that I get 3 weeks pay, and you're telling me I get 8 months pay? And I explained it to him, but he still couldn't wrap his head around it. He said, this is the government telling me one thing. They must know what they're talking about. And he ended up not pursuing the matter just because it seemed to him to be so strange that the government will tell him one thing and now would tell him something very different. So he did not pursue his matter and walked away from over 7 months of pay that he's owed. Yeah. And it's still, this was a couple of years ago, it still bugs me to this day, and I almost feel that I let this guy down, that I didn't explain things to him the way I should have. So please don't let that happen to you. If you lost your job, you need to get your full entitlements, your common law entitlements. You call me, you don't like me, call another employment lawyer. But you have to get proper legal advice. You cannot rely on the Ministry of Labor.
When can you rely on the Ministry? For what? Where do I go? When do I go to them?
So pretty much for anything other than termination, it's acceptable and it's okay to deal with the Ministry of Labor. So overtime issues, vacation pay issues, hours of work issues, absolutely perfectly appropriate to call the Ministry of Labor, and with respect to that, they can advise you, they can even help you enforce those rights, which is perfectly fine. But if you lost your job, concerned about losing your job, maybe it's a constructive dismissal, maybe you're dealing with a poison work environment, things that make it difficult for you to continue working. Unfortunately, the Ministry of Labor cannot help you. This is not me saying so, this is not my opinion, that's a fact. So hours of work, absolutely. Anything to do with your work condition, termination of employment, you have to get proper advice, John.
You think it would be so difficult for them just to put up there, please contact a lawyer for you may have additional entitlements. That's all they would have to do, right?
And I've advocated that for years and years. You've heard me say that. It would be extremely simple. It would be extremely easy. So far, they haven't done that, and it's misleading people. You may think that, wait a second, if I lost my job, it's the natural thing to do to call the Ministry of Labor. They even have a 1-800 number. They make it easy for you. But unfortunately, not as relates to termination of employment. Severancepaycalculator.com. you call me, you get some advice, and you figure out exactly what you're owed, John.
We're wrapping for another week. 1-855-821-5900. EmploymentHourTV.ca is the website. Anytime, an email. Lior and his staff will answer. help@employmenthour.com. Enjoy the rest of your Saturday morning. It's been the Employment Hour in 30 right here on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.